suit and tie and get your hair cut way up high. Get yourself a lawyer, son. You're gonna need a real good one.
David Whiting is here to dispense some free legal advice, so draw near 1300 222 774 if you'd like his words of wisdom today. David Whiting, hello.
Hello.
Hello. Good morning. How are you?
Good morning. We've managed to get this far. I've gone very well, thank you. It's been an interesting week.
Why?
You gave me so much homework last week. It was fascinating.
Yes, there was a bit, so let's get going on that. What do you have?
Well, Colin from Ballarat wanted to know whether, if the need arose, he could urinate on the rear tyre of his vehicle.
Oh, that's
and
right,
the
yes.
answer is there's a piece of legislation which is not current law that related to the management of hackney carriages in the UK, and that dated from 1831, and it essentially talked about whether or not you could leave a hackney carriage unattended. So I think it's likely to be that there is no law that says that. It's likely to have been in relation to someone who was possibly prosecuted for leaving their hackney carriage, and for a hackney carriage you actually need a horse, not just horsepower. So the answer is not good law in Australia. Don't try it, Colin. And the other one was Anthony. And Anthony, we were talking about the Marriage Act from 1961, which is a Commonwealth piece of legislation. And the question was essentially whether or not someone could be electronically present rather than physically present. So the question is, in the presence of.
Yes.
There have been no cases that dealt with that particular provision, but I can, and to be really honest, Virginia, it's not an argument you'd have, because the cost of having the argument is more than the cost of any wedding's ever going to be. But I can tell you that it is possible to conduct a proxy, to be a party to a marriage in Utah in the United States.
Really?
It's not necessary for you to be a citizen. It is not necessary for you to be a resident of the state of Utah.
No, well, in the state of
It is
Utah,
possible
they just like you to marry and marry a lot. And
well, it
marry a
doesn't
number
cost
of
a lot.
people.
I think it's $50.
Right. Okay.
And you upload your documents and you attend, and the witnesses attend via Zoom, and those marriages have been found to be valid marriages for the purpose of migration to Australia.
Yes.
So answer is no, you can't. Well, sorry, I wouldn't. I can see the argument, but I would not be recommending doing it under Australian law.
Mm-hmm.
And Anthony, I actually thought of Anthony in terms of a migration issue, but it's not. Of course, the COVID restrictions say there are to be no marriages in Victoria unless it's end of life or deportation.
Okay.
So can do it.
Yep.
Just, yes. There are two states. I don't know what the other one is, but Utah is okay.
Okay, all right. I don't know if Utah's going to be used as an option here, but there you go. I hope you're still listening from last week, and that's your advice. But we've got some new advice to hand out. 1300 222 774 is the number. Michael in Brighton, you get to be first up today. Good morning. Go ahead.
Good morning. David, here's a question that I think you've never been asked previously in all your years on radio. I have a friend selling his house and wants to know if he has to declare in the Section 32 thing that he believes there's a ghost living in the house.
Yeah, that's...
Wow.
Wow.
First of all, you have to believe in ghosts, Michael.
True.
Yeah, well, let's presume that is so, but does he have to declare it?
If he believes that there is a ghost there, then under Section 12 of the Sale of Land Act is something he ought to disclose, yes. I know it sounds like madness, but it would be something that would be relevant to him were he buying.
You serious?
I would have said yes.
He actually has to fill out that section and say, I believe there's a ghost here.
There's a provision in the Act that says if there is anything that you think a purchaser would need to know when making a decision to buy the property, then you ought to tell them. In fact, you have an obligation to tell them. It's a
Michael,
criminal offence.
is your friend bothered by the ghost, or is the ghost friendly?
Well, little things get moved around in the middle of the house in the middle of the night.
Mm-hmm.
There's sudden chills in certain rooms, and his dog would sometimes suddenly growl and stare at something in certain rooms where my friend says there's nothing there. He's not terribly troubled about it, but he says it's absolutely real.
Michael, if you don't think that it's a factor that would have prospective... Well, first of all, you've got to believe it to be real. And secondly, you need to believe that it's a factor that would be relevant to a buyer. So they're the two thresholds. Right?
Okay.
But I would want to know, if you told me that there was a ghost, I'd want to know if it was friendly or otherwise.
Yes, I think your friend needs to make clear in that section that it's, at this stage, a friendly ghost, although we don't know how the ghost will respond to the new person. Michael, do we?
David, have you ever been asked this before?
No.
There you go. We've broken new
it's
ground.
a law change, Michael, from about 18 months ago that makes it necessary to make these kinds of disclosures.
Thank you, David.
Michael,
Thanks, Michael.
Does your friend feel morally obliged to disclose? Is your friend troubled by this?
No, he feels morally obliged to sell his house and put money in his pocket.
Great to talk to you, Michael. Good luck. So many questions we could ask right here, but we'd probably best move along. Missy in Yarraville, how can we help? Good morning.
Thanks for taking my call. I'm having a bit of a tussle with Airbnb at the moment. I have a booking in Sydney, and the expectation from Airbnb is that I cancel the booking. And if I cancel the booking, I only get a 50% refund. However, my perspective is that the host is currently in Sydney and under lockdown conditions, and that they legitimately can't offer the service because to do so, they would be in breach of a public health order. And it seems
Missy,
that
how far ahead is the booking?
The booking's in 3 weeks.
I probably wouldn't do anything at this point in time, because it's conceivable, unlikely, but conceivable, that the rules will change in 3 weeks' time.
Mm-hmm.
Right? And if you then were to, and I would leave Airbnb alone for the time being because I'm not really keen on this approach, I would be dealing with your credit card company, and I would go back to Visa or MasterCard and say they're not permitted by law to offer the service in that period. I'm disputing the transaction.
That is spectacular advice. Thank you.
All right.
Okay.
Hope that's useful.
Glad to help.
Well done. Anna in Moorabbin, good morning.
Oh, hi, Virginia and David. I'm ringing on behalf of my brother who lives in Frankston Council area. He's on a property, and this is another fencing issue because I know you love fencing issues.
Love them.
Love them. Next door to him are developing. It hasn't gone to council as yet. There's fence palings falling off everywhere. They're trying to fix them. They don't know who the owner is. Very long grass, snakes coming up in the area in the heat, of course. Lots of rats, but we all have those. Where does he go? How does he get onto the owner to get the fence fixed? It is dangerous. The grass, which was probably 4 or 5 feet high.
Okay. Well, let's hear from David.
Anna,
on this.
there's two parts to that, right?
Yep.
In terms, if you think the grass is a fire hazard, you talk to council.
Mm-hmm.
Right, I'm having a feisty dispute with a council officer in a city municipality over an estate that I manage, where there's disputes as to the quality of the maintenance of the property. So if you think it's a fire hazard, you shall tell council and they can serve a notice requiring that it be fixed. Council should also be able to tell you the name of the adjoining owner. If they can't, then you can do a title search, and a title search will tell you the name of the owner.
Okay. Does that cost money to
Right,
do a title search? Or
About $20.
okay, it's a title search for the property owner. Okay,
Good
that's
luck.
great.
But the council should be able to tell you. In fact, the council can tell you whether in this privacy-mad world they will. It's a different question.
Good luck with that. Francis in Gisborne, what's the problem?
Oh, hello there, David and Virginia. I've just got a query about water. Who is responsible for rainwater running across from one property to another. I've got a neighbour that's a higher level than me, and I know we've had a terrible lot of water, but a lot of rain, but we've got water running through his property, landing in ours. And I've spoken to him about it, and he said he has farm behind him, vacant farmland. And he said, the water's running through there. It's coming straight through, nothing we can do about it. I would just like to know if there's who I can talk to and who is responsible, because we're just getting massive amounts of water.
Okay, David.
And were you before, Frances?
I've only had it once, really, before.
And that was last weekend. Yep.
And no, it was a couple of years ago. But it just seems to be a mess. And I thought, well, what I'll try and do is put a garden bed along the side. So I raised the soil, and I thought, well, if there's any runoff, it might go in there and it won't be so much. But it's even gone through the water, through the garden bed, and pools, and then causes a river running down to my frontage. But
Frances, it's the issue is really whether or not there's been a redirection of water or a change of the flow. So the mere fact that water runs from your property, from your neighbour's property to yours, doesn't mean that there's anything wrong or improper.
Yep, I understand.
Because the question becomes is it an unreasonable flow, and the extent to which your neighbour has contributed to it. Yep. So if there is simply you live next door to a property, you're downhill, nobody's touched the property in 50 years, you're stuck. The drainage is your issue, not theirs, because you would never be able to argue that the flow was unreasonable. But if I was to move in next door to you and pave my backyard, then and so there's an incredible amount of runoff. Yes, that's a problem that I've caused and I'm responsible for it. So the question that I would be looking, I'd probably talk to your neighbour and see, well, is any of this the agricultural land further up the hill from you? Have they done some work on their property which has meant it's now draining differently?
All right, and so what's the best way of Frances doing that, David?
Well, I would probably... I would start with talking to the neighbour to see if there's a change from your neighbour's perspective about water flowing onto his property.
Yeah, I've spoken to him and he said no. And he said he checked the rain when we had that massive rain on Friday. He said, no, it's definitely coming straight through the property, straight from the farmland, which has got a slight incline. We're both on over 1 acre. So it's just ending up at my.
Sure. Well, David, what's your final bit of advice here?
The final bit of advice would be talking to the farmer and see whether some of it might get redirected.
Frances has had that conversation, but I guess David's suggesting you have another go at it. Good luck with that, and sorry we can't take it any further. Vanessa is in Upwey. Vanessa, good morning.
Good morning, Virginia and David. I just had a question about at what point within a hospital environment does duty of care become coercive control?
Can you get to a specific for us?
I can. My 91-year-old veteran neighbour was admitted to hospital 4 weeks ago. For the last 2 weeks, the nurses have apparently been under doctor's orders to minimise phone contact with the people who have pretty much been his rock throughout the pandemic and the June storms and whatever he's needed. They've basically blocked us from talking to him very often. In the last 2 weeks, we've had a handful of phone calls with him. Usually we're told that he's off the ward or he's asleep or he's not able to answer his phone or for whatever reason. And we're very concerned about his mental health and don't feel that isolation should really be used as a form of behaviour management, especially as he's had a diagnosis of dementia.
Is your suggestion that the hospital is using phone as a behavioural management tool?
It feels that way because we've been told that he's distressed after speaking with us.
And of course, physical visits are actually very hard.
That's right.
I would be probably complaining to the hospital. There is a health complaints commissioner. if you think that the responsibility ought to be sheeted home to the medical practitioner who has said to the nurses, restrict the phone calls. Does this person have a next of kin, or is there somebody else who can intercede on this person's behalf?
The next of kin has been deemed also not suitable to speak to this gentleman as well.
They can't do that, can they? They can't legally prevent a next of kin, a formal next of kin, from speaking, David?
No, but I think that the hospital/doctor will be dealing with it as part of appropriate treatment. Keep the patient calm and managing it on that basis. But there needs to be some communication. I would start with complaining to the hospital. If you don't get what you want from the hospital, talk to the Health Complaints Commissioner.
Does that take some time? Is that a lengthy and time-consuming process doing that, David?
No, they're both very quick.
Okay.
But certainly I would take the matter up with the hospital today.
Hospital
just
administration.
Not with a person on the ward.
Yeah.
Yes.
Yep. Bump it up higher, and hopefully that might work. Josh in Fitzroy North, good morning.
Morning. Hi, how you doing?
Good.
Hi, David. Question for you. I bought a property that has been subdivided. There's a block of flats on one property, and there was a spare piece of land, vacant land, on the other part of the property. I bought the block of flats. The property was subdivided. They sold the vacant lot. The guy I bought it from sold the vacant lot with a plan for a building on it, a four-bedroom family home. The person bought the vacant land. They've built the family home on it, and now they're saying that my property, the block of flats, overlooks their property. And they said that the person I bought it from was aware when they designed the home that there would be overlooking issues and was going to get screens put up. I was never told about that when I bought the property.
Josh, those conditions would need to be in your building permit, not in your neighbour's building permit.
Right.
So if I was to build a house next door to you, my building permit would not say Josh needs to put up screens. What would happen would be is that Josh's building permit would have to say you can't overlook the property next door.
So I'm not aware that I actually have a building permit. The building I bought was already built. It was already there.
I understand, but there will have been a building permit. I've acted for people in the past where there was a requirement for screens or obscured glass to make sure that in particular circumstances there was no overlooking. But they tend to be when you're building next to an existing structure, not when you're building next to a non-existing structure. So if you were to go to your council, which will be Yarra, Yarra will be able to tell you whether there are any building or planning permits that exist in relation to your building with conditions on them.
Okay, perfect. All right,
but it's not, whatever's on your neighbours is not your problem.
Good luck.
Got it. Understood. Thanks, Dave.
Okay, hope that's helpful. Thank you. Jenny in Leongatha. How can David help? Hello.
Hello, Virginia and David. Thank you. I have a septic system which has pipes extending to the boundary, and they're just 10 centimetres under the surface, and we don't have therefore any plants growing over that, and that's it's only a domestic sized block. On the boundary, 1 metre on the other side of our fence, there's a large tree, and it has lateral roots, and those roots are impinging on our property. They're about 10 centimetres thick at the moment, but it's it will be a 30-metre tree in time. So we have a problem with those roots. Are going to destroy a section of the septic system. The neighbour is an elderly person and doesn't want to remove the tree. We have spoken very civilly about it, but he's got an emotional attachment to the tree, and it's growing about 1 metre a month. And he doesn't think there's a problem because he thinks the roots are going down. Well, we can prove that they're not, but he's older and recalcitrant about it. What we're wondering is whether you can actually, in law, legally, cut the roots parallel to the fence, down from the fence, to stop those roots destroying our septic system on that section. Legally do that. It's an aggressive action that I'm not comfortable with, but there aren't too many options in this case, and one of them might be.
The short answer is that you can, but you need to be careful that you don't weaken the tree in the process.
Yeah,
See, if the tree got If what you're doing is you're planning to cut all the roots a metre from the trunk.
Yes, that's right. On one,
that will
yes.
probably substantially unbalance the tree.
Yes.
And might create a significant difficulty for which you would be liable.
Yeah.
We would be liable for the weakening of the tree, even though legally we could do it.
You're allowed to exercise self-help, but everything comes at a consequence.
Yeah.
Okay.
The question, it's this balancing exercise, and I don't mean balancing the tree. The issue is that if you, by exercising your rights, you create a problem in the property next door, you may well be liable. What you're looking for, I would have thought, was some kind of root barrier. But that
would do the same thing, because we'd have to cut the roots to put the barrier in.
Yes, but you wouldn't necessarily do it right on the fence line. Anyway,
Well,
you've got exactly the same problem. I mean, and the jurisdiction for this is the Magistrates Court.
Yes. Okay,
so you're
fine,
going
thank
off
you.
to the Magistrates Court to say that, look, I need to issue, what I want is an order that your elderly neighbour remove his tree roots from his property, from your property.
Okay.
And the way you achieve that is, the way the court would achieve that would essentially be direct him to pull down the tree.
Okay, is that an expensive process?
It depends on how hard your neighbour fights the issue.
Okay, fine. With what legal fees? I'm embroiled in with a solicitor to handle it on my behalf.
Yes, you would be.
Yeah. Okay,
Yeah.
so
I could see $10,000 going in the blink of an eye, Jenny.
Yes. Okay, one of those open-ended ones.
Sorry about
Legally
that, Jenny. That sounds really, really tricky. Yeah, the problem that the catch-22 you outlined there, David, is a real one, because if that tree is weakened by anything that Jenny and her family do, and the tree then, falls on a structure, she's entirely liable, isn't she?
Yes, well, more likely than not, but also if it damages somebody inside the structure.
Well, of course, yes.
Yeah,
but I mean, I've just, if it falls over and creates damage, then it goes back to her action in tampering with the roots.
Yeah, it's just too much of a problem. Yeah.
Yeah.
It sounds really good in principle.
Yeah.
But if you cause the tree to fall over, then you have the consequences of your own action.
And a very senior arborist, who also would be expensive, but maybe not as expensive, a very accomplished arborist wouldn't be able to come in and pose a solution?
The difficulty is going to be making sure that the roots don't go that far. Now, they're already 10 centimetres.
Yeah.
They're not going to get any smaller. They're going to get bigger and extend further. And the message that Jenny was saying, it's growing a metre a month, which is mammoth.
It's absolutely mammoth. It's moving at a rate of knots. We'll have to leave it there. We've run out of time now for calls, but terrific to help all of you that we could. And David, always good to speak to you. Thanks so much.
Thanks.
David Whiting there, Melbourne solicitor.